Good afternoon, dear colleagues, public and candidate. The advisory group of experts continues with interviews with candidates for a position of a judge at the Constitutional Court of Ukraine. Our next candidate is Mr. Ihor Yarchak, a candidate who currently holds the position of the Director of the Legal Department of the National Anti-Corruption Bureau of Ukraine. We are ready to start with the interview. I will pass first the floor to our Secretary of Advisory Group of Experts, Mr. Yaroslav Romaniuk, who will explain you the process of this interview and some other details, and then we will start with questions. Yaroslav, please.
Дякую, пане голово.
Thank you, Mr. Chair. Good afternoon, Mr. Ihor. Also welcome everyone who is right now watching the broadcast of our session. Ihor, today all 6 members of the AGE are present at the interview, including Chair of the AGE, Mr. Aleš Zalar, members of the AGE, Ms. Maureen O'Connor, Ms. Hanna Sukhotska, and Ms. Oksana Vasilchenko, member of the AGE, Mr. Vasil Shakun, and I, as the Secretary of the AGE, Yaroslav Romaniuk. Besides, during the interview, we have observers, deputy members of the AGE. Now we have 5 of them, that is Richard Barrett, Marek Zubik, Volodymyr Kuzmenko, Vitaly Makhinchuk, and Thomas Griffith, who is participating in the meeting of the AGE remotely. I will briefly explain the regulatory framework and the procedure of the interview conduct for you. The interview is one of the mandatory stages of assessing the criterion of high moral qualities of candidates for the position of the judge of the Constitutional Court of Ukraine. The advisory group conducts interviews with candidates in accordance with Article 7 of the methodology, in particular to clarify and refute any doubts about their high moral qualities. So actually that is in your interest, so that you would have the possibility to refute that negative information that the AGE might have with respect to you, as well as to try to refute those doubts about your integrity which the AGE might have with respect to your candidacy for the position of the judge of the Constitutional Court of Ukraine. While processing materials about you, Mr. Ihor, the AGE sent to you questions for written explanations, and you had the opportunity to prepare. You provided such answers, and we are grateful to you for the communication with the advisory group of experts and for allowing us to get more comprehensive information about you as the candidate. In this context, I would like to draw attention that according to Article 7.8 of the methodology today, Mr. Ihor, you may not provide information, documents, or other materials which we requested before, and for some reason you did not do that, or that you would like to provide today upon your own initiative, which you could provide before, but you did not do that for some reason. At the same time, we may grant an exception from this general rule if we decide that there is a justification for such exception. I would also like to inform you that this interview is being recorded and broadcast live at resources of the AGE and at the website of the Constitutional Court of Ukraine. Therefore, I would like to draw attention of the AGE members and your attention, Mr. Ihor, to the fact that it is necessary to restrict the use of sensitive data and restricted information during the live broadcast. If necessary, in the process of our communication with you, we will suspend the broadcast, so that this information, which is restricted, would not be disclosed and would remain in these premises. Also, Mr. Ihor, I would like to draw attention to the fact that we plan to complete this interview with you in approximately 1 hour. We ask you to provide answers to the questions that you will receive from us in a concise and brief way, trying to answer them for up to 3 minutes. Before the end of the interview, you will have the possibility to address the AGE with concluding remarks that should not last more than 5 minutes. And now we are ready to start our interview with you. I would only like to draw attention to the fact that our foreign members of the AGE do not know Ukrainian, so they will ask their questions in English, and if your level of English is not enough to understand the question, you have the possibility to use the headphones that you can see on the table, and the blue light means that you can listen to simultaneous interpretation from Ukrainian into English and vice versa. So now we are ready to start our interview with you. The co-rapporteurs about you is Ms. Maureen O'Connor and I, Yaroslav Romaniuk. I will start from questions. Mr. Ihor, with respect to higher legal education, you started your activities in the prosecutor's office, and it was quite a successful start of your professional career in the prosecutor's office. You were the intern, assistant of the prosecutor, investigator of the prosecutor's office, in different prosecutor's offices actually. Then later on your career improved and you started working in the prosecutor's office of the regional level. You were the prosecutor of the department, senior prosecutor of the department. But after 11 years of working in the prosecutor's office, you voluntarily resigned from the prosecutor's office. Can you please explain why? What was the motivation? What was the reason of your resignation from the prosecutorial service, whether your career was quite good? Thank you for your question. First of all, yes, really, I would like to say that my career in the prosecutor's office was quite successful. First of all, it was happening in such a way because I was improving myself all the time. I tried to develop myself comprehensively. I tried reasons of your resignation. Yes, I understand your question. Okay. Reasons for resignations were related to the financial situation in my family. Back then I had a young family. I had a minor son who required financial support. My wife was on maternity leave. She did not have the possibility to earn money, and I faced the question how I should provide for my family further. Back then we lived in the apartment of my wife's parents. So you were dissatisfied with the financial situation? Yes. We should not perceive that as the situation that you chose the financial situation rather than serving the people of Ukraine. No, that's not true. It was the necessity because I had to provide for my family financially. Okay, I understand. You stopped working in the prosecutor's office in 2011 and you moved to Kiev the same year. Did you have a real estate object in Kiev? Did you have accommodation here? No. Where did you live in Kiev? At the very beginning, I stayed at my relative's place. That is the aunt of your father-in-law. Yes. And how long did you live there? For about a year and a half, we lived at her apartment. And what about further period of time? In September of 2014, our second son was born, and we could not annoy the aunt in such a way. Besides, we as a young family with 2 children could not live there anymore, and for some period of time we rented an apartment. So we found an apartment, we rented it, we moved there, and for some period of time we lived there. Okay, I understand. Can you please tell us about the story of the apartment where you live now? What is the apartment? That's the apartment which is now owned by my wife's father. He received it from the aunt. So that's the aunt with whom you lived when you moved to Kiev. Yes, that's the cousin did she have 2 apartments? No, she had 1 apartment. As of the moment when we lived at her place, when she offered assistance, she had 1 apartment. And what about further movements? Her minor son used to live with her, so accordingly she thought that he was almost of my age. So she thought about the way how she could improve his living situation, and she was registered to receive an apartment from the local self-governance body. And under social program, she bought the apartment using funds partially borrowed by my father-in-law. So my father-in-law back then sold 1-room apartment. He had a 1-room apartment in Lviv. He sold it, and he thought as he wanted to borrow this money to us, but this money was of course not enough to buy an apartment for us. And since back then we lived in the aunt's apartment, so having learned about this sale and intentions of our father-in-law, that he wanted to support us, we told him that back then the aunt also required help, and we asked him to borrow this money to the aunt. And accordingly, sometime later, it happened that the aunt could not repay the funds, right? So she had to repay that from the sale of the cottage house, but she could not do that. So she offered that she could terminate the loan and gift in the apartment. Do I understand you correctly, Ihor? Your father-in-law sold the apartment, used these funds to borrow them to his cousin. She bought that apartment, but since she could not repay the loan to your father-in-law, so she gifted that apartment to your father-in-law, right? Yes. And since then, you have lived in that apartment. Yes, absolutely correct. When my father-in-law, absolutely correct, so everything was correct, yes. When my father-in-law obtained the right of ownership, no, that's, back then we lived in the rented apartment. Yuri, we've established the fact, okay, thank you. In your opinion, from the perspective of an external observer, doesn't it look the following way? This apartment was actually bought by you using your funds, which you earned somehow, but in order not to have your surname in the documents and in order to avoid questions about the source of origin of funds, you had this scheme done through the aunt, father-in-law, but actually you have lived there since the very beginning. I understand your concern about these circumstances, but I would like to say the following. Back then, I did not work in public authorities. I resigned there in 2010. So I was not the employee of the institution which required special control regarding property, etc. So I had no need to hide this purchase. So, okay, that is wrong perception, yes. Moreover, if you pay attention, I've specified that funds were borrowed by my father-in-law at the expense of the sale of the apartment which he owned and which he sold in Lviv. So these were funds which he received from the sale of the apartment. Okay, and where did your father-in-law live? He sold his apartment? No, back then he lived at the apartment together with his wife, and he got that apartment as a result of the death of his parents, so inherited that apartment. Yes, actually he inherited it. Okay. Ihor, close to Kiev, in Vita Poštava, you bought a land plot. What was the price of this land plot? As of the moment of the purchase of this land plot, it was valuated at approximately $65,000. Okay. Was this a bare land plot, or was there some unfinished structure there? As of the moment of sale and purchase, there was a structure on it. It was unfinished construction object, but it was not registered following the procedure established by the law. So it was not registered as unfinished construction object. But actually it was a land plot where construction was initiated without registration, but still it was there. As of the moment of the agreement conclusion, the legislation required to specify finished construction objects in the agreement. Now, No, that's not criticism. We are just establishing the fact. Yes. So you continued. So you completed construction of the structure, right? Yes. I systematically continue construction of this building. In 2022, my wife and I submitted a notification on the start of construction works, and since then, from time to time, we try to bring it to the condition that would be suitable for living. As of now, the condition is not like that. It does not have enough conditions in order for it could be used as accommodation. Okay, this land plot in Vita Poštava was bought in 2021. A year before that, in 2020, you bought another land plot in Hatne. Was there unfinished construction there as well? No, it was a bare land plot. What was the purpose? Why did you buy it? I will explain. As of 2020, I think you will have the next question as well about that. My wife received official accommodation in 2018, and we hope that sometime later we would be able to move into that apartment. But for a long time, the developer could not finish that construction. The developer delayed the process of commissioning of the apartment, so we had a critical issue where we would live, because 4 people find it difficult to live in a one-room apartment. But you still live there in the apartment? Yes. Well, because the situation in Ukraine right now forces us to live there for now. But actually now we are ready to move into the apartment which was provided to my wife as service accommodation. Are repair works finished there? Yes, it is ready, and actually we are ready for that, but the only thing is that my wife is concerned about the location of that apartment, because the apartment is located close to objects which cause concerns, and it makes us think whether we should move that. I've specified in my explanations which objects are located nearby, so I think I should not voice them due to security considerations. So again, you have not moved to the service apartment because it is located close to, not far from the military object danger. Yes, it's civil object which can be the target of different attacks. Okay, the civilian infrastructure object which could attract the attractor's attention. Yes, but that is my wife's position. Personally, I believe that there is no difference between the current apartment where we live now and between the apartment which she has been provided by the prosecutor's office. So I think that I can convince my wife. You're absolutely right, because you live in the apartment. We've clarified this issue, which is twice closer to that civilian infrastructure object that you're talking about. The matter is that there are peculiarities. Maybe then let's suspend the broadcast for a second and I will explain the peculiarities, because there are some peculiarities from the perspective of security. I would not like to voice them publicly. Okay, if necessary, we will suspend the broadcast in order to clarify this issue. But, okay, how do you use this service apartment now? We do not use it. I did repair works there. I brought it actually to the condition that is already ready for use. Does anyone live there? No, no one lives there. I'm telling you that we are ready to move there, and I think that in the near future we will move there. We've established how much electricity is used there, and now we have a logical question, because quite a high level of consumption as for the apartment where nobody lives. There is such an impression that someone lives there. Maybe you're renting it out? No, absolutely wrong. Look, if you pay attention to that information, and I've provided this information to you, in early 2023, consumption was not high. There was some consumption, but not high. And winter was not that cold. So heating there is not very functioning. There is a problem with energy efficiency in the apartment. And in 2023, winter was not cold, and we did not have to spend additional resources and use additional appliances for heating. This year, winter was sort of aggressive, and when I started doing repair works, so during the entire winter period, I was doing repair works there, and that heating was not enough for the apartment to be comfortable for repair works. So no one lives there? No, no one lives there. And I can show the apartment to members of the AG. No one lives there. I'm ready to show that. Okay, it's clear.
Ihor Stepanovich, you are in Kiev as of 2011. As of 2013, you live in the apartment that was given to you by your father-in-law. In 2020 or in 2021, you purchased the land plot without completed construction near Kiev, and you also take measures to complete this construction. And after that, your wife gets the official accommodation apartment. What for? Aren't you provided with accommodation? Don't you have where to live? It's a bit incorrect. My wife got the official accommodation in 2018. Yes, you did mention this, but you said that the construction wasn't completed and you couldn't live there. Well, the decision about this official apartment was made in 2018, and then we did not have the land plot in Gatne, and we didn't have the land plot in Vita Poshtova. So we don't know about these objects, and of course we were very happy at this decision by the prosecutor's office. And then in 2020 we did have these objects, and they required some works, construction works. And you have noticed that the house in Vita Poshtova up till now hasn't been finalized yet. So we are doing the works as much as we can, and we try to do it on our own. Also, our relatives help out. My wife helps out to do the repairing works and the refurbishment. I provided the photos of the building, and you can see that the house is not built rapidly. Yes, we have the photos. We are familiar with it. Thank you, Ihor Stepanovich. I have another question about the land plot that was purchased by you in 2020. In 2020, according to the information that we have, you have purchased it with $26,000. And is it true? Yes. And next, in 2022, you sold this land plot, right? Yes. For how much? For the amount that is specified. I don't want to speak about it. It is significant amount. And due to this, there's a question. You purchased the land plot before the war, but you sell it during the war, and the price grows almost, it's 6 times higher. How did you manage to do that? How did you manage to sell it for 6 times the price during the war and so fast? In 2020 you bought, and in 2022 you sold it. So what's the point? I can explain it, the situation. In 2020 we purchased this plot in Hatne so that we could build the house there, and I gave you the design of this house, the copy of it. And at the end of that year, together with the designer and the architect, we have developed the project for construction, and in 2021 wanted to begin. So we have accumulated some amount of money, and we have requested the contractor to do the preliminary assessment for how much he can do the construction works. But it just so happened that in 2021 the building materials increased in price, and when he arrived to the facility, to the land plot, and checked the project, he said that the funds that we managed to accumulate, that he won't be able to do it with that money. So since he was a good friend of mine, he gave me some advice, and he said, do not organize this work now, because you will not be able to do the finishing of the house. But how did you manage to sell it at such a high price? Well, I understand, but this land plot is near the capital market, and To me, it's unknown why the previous seller has sold it at this price, but she offered me certain price, which, in my opinion, at that moment was in line with the price in this town. It is martial law, yes, but I have monitored the situation on the market, and at the moment when I was selling my land plot, the demand for the land plot in this area increased. This land plot is the corner one, so it doesn't have neighbors on the three sides of it, and okay, but this was also in 2020, but you managed to purchase it at such a low price and sold it so expensively. You know what it can look like to the observers, that this is just the legalization of funds obtained illegally. Dear experts, I can provide you all the documents. I can give you the possibility to communicate with the previous owner. I can give you the opportunity to communicate with the new owner who decided to buy this land plot. Trust me, there was no mechanism connected with the legalization of this land plot. This was just a good deal, not more, not less. But in our family, we had another case of a failure of a bad sale and purchase. So maybe this was when we didn't get lucky once, but then we got lucky for the second time. It looks like you have funds to purchase one land plot, second land plot, for the construction of the house, for the repair works in the official apartment, and at the same time the aim of obtaining a free official apartment from the state when you have the chance to purchase your own at your own funds. It looks a bit can I explain myself? In 2016, the mother of my wife moved in with us, and she did this to help my wife with our son. And it just happened so that sometime later we learned that she had cancer, and during 3.5 years, all our financial savings that we have accumulated prior to this, all of our income, my wife's and mine, that we obtained in this period of time, we had to spend it on her treatment. And believe me, we have undergone a very difficult stage or phase, and we of course try to do everything possible to save the life of my wife's mother. That's why this period of time, from our family budget, a lot of money has been spent. So, and next, if you can see that we did have enough of income so that we could accumulate enough funds and to purchase the objects. I understand your answer. A few more questions I have for you as for the loan. You got the loan for the amount 170,000 USD. Which year was that? 2007. What was the aim of the loan? I was married, and I had established a family. And okay, so you tell us clearly, to purchase the apartment. Well, I lived with my wife back then, and her parents were helping us. Was this loan provided with something? It was the house of my mother, so it was. What is the cost of the house? It was around $170,000. So, and the bank did not agree to give you this loan. Yes. Under this collateral, yes, the bank had to provide for the liquidity of this loan, and they requested also another collateral. I see. So the aim was to improve your living conditions. You take the loan of $170,000, and the cost of the house was the same. The aim was to move in together with my parents and my wife's parents and to live all together. What happened next? Did you manage to implement this aim? This was the case, a negative situation actually, when in 2008 the world crisis occurred and the exchange rate from 5 hryvnias increased till 8 hryvnias per dollar. And because of such events, the demand for the real estate got decreased, and we were counting that we would be able to repay this loan if we sell the house of my father. So my father had this. What was the interest rate of the loan? I cannot tell you for sure, but I think it was like 12.45. And what was the amount that you had to repay? At the moment when I got the loan, I did not know about the amount because the agreement did not say the size of the interest rate, but only the schedule for repayment, but no interest rate. Later on, when I found out, so you took the loan without understanding the interest rate, I can explain myself. When we took the loan, we already had a few clients for the purchase of the house that belonged to my father, but they were not ready to purchase it because they needed to sell their real estate objects. So the question was to obtain the loan, not to lose the possibility to purchase this house. Do I understand you correctly? You take the loan to buy the house in order to move in with your parents and to repay this loan selling the house that belongs to your father by selling it. Yes. And how can you then explain this document that we have and this receipt that it was not about your father's house, but your house, where you said that you were supposed to live? I think this was like a misprint. It was not intentional. I gave this house to my father in 1999, so this was just a mechanical mistake. How much time did it take you to repay the loan? As of 2007, my father was repaying it up till 2012, if I'm not mistaken. So almost 5 years. According to our data, around 112,000 were paid. Thanks to what? The house wasn't sold. You're quite right. I did not have the possibility to repay because my income was not enough to repay the loan. So I provided you the corresponding documents about my income. So why wasn't the father's house was sold? Well, we thought that we would sell this house in 2 or 3 months, and we wanted to repay the loan sooner. So we didn't think that we would be paying every month, do these, payments scheduled, but we thought that we would do it much sooner. But the father was repaying it. And the question is, which money did he use to do this? The father was hoping that he was going to regulate this matter, and he requested assistance from our relatives and acquaintances, as they have been living abroad, and they were helping him with the funds that they managed to make abroad, and the receipts were provided. Also, he went to his acquaintances he was friendly with, so he borrowed money. Yes, he borrowed money. So if you had an opportunity to borrow such a big amount of money without percentage, without interest rate from your relatives, so what was the point of obtaining the loan if you could just borrow it from your relatives? Well, first of all, this was due to the necessity of sudden need to obtain this amount of 170,000, because the seller in the street of Kopach did not want to wait long. He set us the timeline for settlement for this house. Otherwise, he said he would look for another one. Clearly, that even borrowing such amount from our relatives, we couldn't. So what is the aim of this loan? What is the fate of this loan? Did you repay it? I repaid to the bank the amount more than $170,000. So what about the interest rate. It was not repaid because we were forced to go to the court to protect our rights. So first you refer to the court yourself, but after you did not appear for the 5th time, your lawsuit was not considered. What is the legal ground? So what? To which extent was the actions of the bank illegal? Well, first reasons why we why we applied for the court was because as of 2018, up 7 till 2014, we were looking for clients for this house so that we could at least reduce the body of the loan and reduce the interest rate that were accrued by the bank each day. We found a few clients and we went to the bank with a suggestion to help us out, but the bank did not agree. And is this the ground for recognizing the agreement illegal? No, I'm explaining why we went to the court. The motives evoked us to go to the court. Personally, my wife, my mother, we understood that we will not be able to regulate this situation with the bank ourselves. I'm asking for the legal grounds to recognize this agreement illegal. Having assessed certain documents that were obtained, I decided that the bank, when giving me the loan, they did not and they didn't assess my solvency correctly, because they were supposed to check the credit rating or solvency, but this is the problem of the bank if they fail to assess your credit worthiness correctly. But if the bank would have done this, then we wouldn't have this argument. So the grounds for recognizing it invalid was the violation of the legislation. My rights were violated because the bank did not fulfill their duties. Because if the bank did fulfill their duties, these legal relations would not have occurred, and I would not have these problems as repaying these funds. So if certain duties are for the parties, then the parties ought to fulfill them. Okay, I see. So you filed a lawsuit to the court, but you did not appear to the court to support your demands. What happened? So then your wife filed the lawsuit. I did went to the court, and the first session took place, and then I realized that it needs clarification by me. So I prepared the application to change the grounds for this lawsuit. At that time, I was very much busy at work. And since I already worked in Kyiv back then, I could not participate via video conferencing, and I had no chance to appear at the court's hearing. Sometime later, I have evaluated the legal practice that existed on these matters, and I realized that the perspective to obtain the positive decision was very low. And basically, I understood that the court will leave this lawsuit without consideration because I did not come to the court's hearing twice. Okay, so finally you got the decision for your benefit. Sorry? Could you please clarify the question? I didn't understand it. This is not the question. This is stating the fact. So you finally got the decision, the court's decision for your benefit. So recognizing this agreement invalid. No, the decision was for the benefit of my wife and my mother because they used other grounds and other motives of their lawsuit. What were they? That in the agreement there was no total amount of payments on agreements, no schedule of repayment of these amounts, and also the agreement had the condition that was aggressive. So the bank has set the agreement that I would pay 1% from the amount of the body of the loan for obtaining these funds. This was an aggressive condition. The court has recognized it, and this was served to recognize it as invalid. And the court did not appeal this decision. I see. Igor Stepanovich. Still, you said that you learned about this judicial practice when the bank didn't study a credit worthiness, and this could serve the grounds for the credit agreement to be recognized invalid. But do you know about the ban for this contradictory or controversial agreements? Because if you refer to some flaws in the agreement, then such behavior of the party to the agreement is considered to be as abuse of their right, and the judicial practice is not inclined to support this behavior. Are you aware or familiar with this kind of practice?
As of the moment when I was filing my claim with the court, I was not aware of this case law. Maybe this case law exists now, but frankly speaking, I have not traced these issues because I don't have these issues now. With respect to the situation related to integrity, I would like to draw attention to the fact that the decision by the court was adopted pursuant to the claim of my wife and my mother, which were not parties to the credit agreement. So, from my side, I believe that I've taken everything possible in order to repay this credit, but we could not find understanding with the bank because the bank forced us actually to sell the object at the price which was not offered to us by the buyers, but we had to find additional funds and to pay additionally to the bank for the bank to allow us to sell this object. We did not have this money to do that. Okay, I understand you. But do you understand how the story looks like from the perspective of an external reasonable observer? That an employee of the regional prosecutor's office who is competent, who has career growth, gets a credit from a bank, agrees to repay the bank, the credit to the bank, pays this credit for 5 years, and then learns about the case law in favor of him, and then challenges this credit agreement because the bank committed some mistakes, and now he doesn't have to repay the interest for the credit. So how can this be perceived by the external observer? I understand your concerns about this, but firstly, really, I received the credit when I was working in the prosecutor's office. I resigned from the prosecutor's office in 2010, and at the moment when I filed a claim with the court, I no longer worked in the prosecutor's office. From the perspective of the external observer, I ask you to understand our situation. We were in the situation when my parents borrowed a huge amount of money, which we had to repay. Okay, we understand. And please understand, we will advise and we will discuss and we will take the decision with respect to your situation. I have some other questions to you, but now I would kindly ask my colleague, Ms. Marina Connor, to ask some of her questions because she also has some questions. Please, Ms. Marin, the floor is yours.
Thank you. Good afternoon.
Good afternoon.
By asking you, Mr. Yarchak, do you consider yourself a public servant in the role that you currently are employed? You're head of the legal department of NABU. Is that correct?
Yes, I'm the civil servant and the head of the legal division. Yes, legal division.
Are you familiar with the concept of being a public servant, not necessarily a civil servant? In other words, you work for a government, but the philosophy of being a public servant.
I know about requirements to the civil servant from the perspective of the law on civil service, so I'm aware of this concept.
What would you say is the required or necessary qualities for being a civil or public servant?
The law does not contain the some personal qualities. The law contains requirements with respect to the competence, with respect to the experience of work, with respect to there are no requirements about qualities in the law on the civil service. At least I'm not aware of that.
So it's merely to be a public or a civil servant, and you would agree that being a judge on the Constitutional Court of Ukraine is a civil servant position, correct?
Абсолютно.
Yes, absolutely correct.
So there's no mention then, or maybe there is, maybe in the oath that you take, I'm not familiar, where there's mention of diligence and honesty and service, putting the public before your personal needs. Is there anything in either the law or any of the oaths that you would take as a public civil servant?
I understand your question, thank you. Yes, really, the law on the civil service contains the oath, but this oath is slightly different in the law on the National Anti-Corruption Bureau, and I took the oath as the employee of the NABU. Even though in the same law there are also requirements, similar requirements to employees of the NABU.
Let me ask a question about your employment with the bank. You were in the banking system, is that correct? After your departure from the prosecutor's office.
After resignation from the prosecutor's office, I worked in the private sector. It was enterprise in the agricultural sector, and later on I really worked in the banking institution.
And what did you do in the banking institution?
I was the deputy head of the legal department. I supported problematic credits. I supported court cases where the bank was the party to the case and the party to the proceedings. Later on, I also supported activities related to activities of regional networks. So the bank where I worked had a network, activity of which had to be supported from the legal perspective, so I supported them in the legal way.
Okay. And were you employed at the bank at the time that the lawsuit with the bank that you had dealt with for the $170,000, when that litigation was going on over the
Yes, yes.
Do you think that being an employee of a bank in the type of employee responsibilities that you had, you said dealing with problem credit issues, do you think that assisted you in making you realize that you may have a cause of action with regard to your current obligation?
In my opinion, yes, of course. That knowledge which I obtained at the bank improved my understanding of the situation which I had with my bank. But I would like to draw your attention to the fact that I was not deprived of the possibility to consult with competent lawyers, and the respective attorneys were consulted by my relatives, so they used attorney services. So I had a general understanding about the relations, and it changed. I had better understanding of our relations with the bank, but in my opinion, it cannot be a sign that I lack integrity. For example, back then, I just had a slightly different understanding of the legal relations which we had.
Okay. How did you end up being employed by the bank? Is it Broke Business Bank? Is that the name of the bank you were with? Am I saying that correctly?
Yes.
And how did you, you said you resigned from the prosecutor's office, then you were working in agriculture, did I hear you say? And then you went to a banking institution. How did that progress?
The matter is that while working as the head of the legal department in Service Agro Center, back then income which I was getting there was not enough to support my family. And of course, I started looking for ways to improve the financial situation. I addressed the management regarding the increase of my salary, so they were not ready to do that, so I started thinking, how can I find the better job? So accordingly, I started looking for different offers on the market, and I was offered through friends to work for a Brock Business Bank. And the salary in this bank was twice as high as my previous salary. So of course, this salary was better for me, and I agreed to this job offer. If you look at the difference between the resignation from the agricultural enterprise and my employment in the bank was very small. It was like 6-7 days, if I'm not mistaken.
Okay. So you went to the bank. When did you start? What year did you start working for the bank?
You know, I can't recollect specifically now. I need to check documents. I assume that approximately it was 2012, 2013.
And then you went to your current position with the legal department at NABU in 2016. Am I correct with that?
Into 2015, in November of 2015.
All right. Now, I have another question to ask about these real estate purchases and ownership and then sales. Your wife was entitled to the service apartment, and that was starting in what year?
She had this right in 2018.
2018. So in 2018, you're working for NABU, apparently making a decent, enough money to support your family, correct?
Верно.
Yes.
And your wife is working as well?
Верно.
Yes.
You have a two-income household, and you have this service apartment that is being, I guess, remodeled to bring it up to the specifications that you need?
Уже не он,
Now it's already remodeled.
In 2018, when she got it? No, you had to remodel it after that.
In 2018, this object was like at the stage of construction. When we went to that object, actually there was no basement, even no foundation. It was like a clear land plot. There were no structures on this land plot actually, and we can't talk about some unfinished construction object even.
Did you and your wife finished this apartment? Is that correct?
No. That construction was built at the expense of the prosecutor's office, like the building itself. As far as I understand, there was some agreement between the prosecutor's office and the developer, and they were developing this and building this apartment.
So when was this apartment given to your wife? And I don't mean when it was under construction. When was the construction finished and it was given to your wife?
In 2011, my wife received the possibility to use this apartment, so they concluded the agreement on maintenance of this apartment. In 2022, this building was commissioned. So until then, the use of this building was impossible. And moreover, I would even tell you that after 2022, there were problems with the use of the apartment because, for example, power supply services, other services were provided only by the developer, not through utility companies, but it was happening through the developer. So payment for electricity was for tariffs like for legal entities. So the use of this apartment was impossible and unreasonable. So only in late 2022, in early 2023, this issue was resolved, and residents of this building had the possibility to use utility services, for example, electricity, as for tariffs for individuals.
You knew at some point, eventually, that you would have this apartment for the use by your family, your wife, yourself, and your children, correct?
Звичайно, так.
Yes, of course.
But in the meantime, you purchased the other properties that Yaroslav referenced and then sold those properties.
Yes. I've drawn your attention to the fact that in 2017 this object was at the stage of the start of construction, and as of the moment when we bought other objects in 2021, this object was not commissioned. And based on conversations with other owners of apartments in this building, in the near future, the commissioning of this building was not expected. And active activities of residents of the building resulted in the situation when the developer had to commission the building, and in 2022, so this possibility emerged. So in 2020, when we bought the land plot, we did not even hope that in the near future we could use this apartment. If you analyze construction situations in Kyiv, there are many objects, construction of which was initiated in many years ago, but which have not been commissioned until now due to some problems related to commissioning of these buildings. So there are some shortcomings, and this building also had some shortcomings which were removed upon the initiative of residents, and then in 2022 this right emerged. But in 2020, 2021, we did not hope that we could quickly move into this apartment.
All right, so again, you're buying a plot of land, you're buying an unfinished house, which needed, obviously, a lot of work at the time you purchase it, and you've got this service apartment that is undergoing development. So and you're living in your father's apartment or your father-in-law's apartment? Which is it?
We live in the apartment of my father-in-law.
Ремонт
From time to time, I conducted repair works in the service apartment, and from time to time, I conduct repair works in Vita Postova, even though we sleep in the apartment of my father-in-law. As I've informed, I'm convinced that in the near future I will convince my wife that we should move to the service apartment, even purely based on the need of our younger son to have a separate room, and that's why I think we will move.
I think that one of the concerns that you mentioned is the location of this apartment and its relationship to the airport, correct?
Yes.
And yet where you are now is, I think, twice as close to the airport, the apartment that you're occupying now, as where the service apartment would be?
ми можемо від...
Can we switch off the broadcast so that I could explain?
Yes.
Can we suspend the broadcasting, please?
I want to now go to an entirely different topic here, sir. In 2016, or since then, you've been a member of the Competition Commission #3 of the National Anti-Corruption Bureau of Ukraine, NABU, your employer, which conducts competitive selection of candidates for vacant positions, correct? In 2016, NABU announced a competition for the vacant position of deputy head of the department within the legal department, which is your department, right?
Верно.
Correct.
All right. And at that time and currently, as you mentioned, you were head of that department. All right. By the decision of the Competition Commission, dated April 11th, 2016, there were 264 candidates admitted to participate in the competition for the vacant position of deputy head of the Department for Special Assets within the legal department, among whom was a citizen, O.V. Sabula, who eventually became the winner of that competition, correct?
Верно.
Yes.
It was established that you and this individual were selected as the winner of the competition, or that person and you had worked together in the private sector, and I'm presuming that was at the bank? Is that correct?
Абсолютно верно.
Correct.
What was your relationship?
У нас было выключено.
We had only professional relationships. So before he was appointed to the bank, I did not know him. We would never communicated, so we did not know each other. But further on, the fate was such that I got fired from the bank, and he also made that same decision to leave. I have communicated with the legal department for the Fund of Guaranteed Contribution that once recommended me for the position of the deputy manager of the legal department in this bank where we got acquainted. So this was not the initiative of Mr. Tsibula, who was the head back then, but it was the initiative of the manager of this department of the funds. I regularly reported to the legal department of Fund of Guaranteed Contributions on the cases that I was responsible for. I could say that I directly cooperated with the management of the Fund of Guaranteed Contributions, so they were aware of my work, about the efficiency of my work, and if you trace the cases that were that I was responsible for, then you will notice that 95% of them were successful for the benefit of those enterprises that I worked as the lawyer and whose interests I was representing. Sometime later, I made a critical decision, thinking that I had to change my job and look for another job because the bank was on the stage of liquidation. And in fact, the situation was the following. I had to, as soon as possible, to stop working in the bank as a lawyer, as I already had a high expert level, and I had to look for a better job and with better conditions for my life. And so I started looking for the job, and in the legal department of the Fund of Guaranteed Contributions, they told me about the Citycom Bank as a temporary job, and I was informed that it's only for 3 months. But as I found out later, Mr. Sabula was also employed there. So for 3 months we have worked there, and sometime later our relationship fell apart. We did not communicate, did not meet. I went to the employment center to register as an employee to look for the job in the state services and to try to find some decent job, a better job. And I have no idea what Mr. Sabula was doing at that period of time. Later, using the website Job or Work UI, I found out about the competition. The competition for the legal specialist, because in the employment center they did not offer me any good job. Yuri Stepanovich, we're not talking about your employment now. We are speaking about the employment of Mr. Tsibula. Have you facilitated his employment in NABU? Thank you for your question. I'm approaching the answer. I won in the competition, and I was selected for the competition commission in the National Anti-Corruption Bureau of Ukraine. And indeed, sometime later, there was a job opening. And as it turned out, Mr. Tsibula also decided to participate in that competition. And I
Recruit him or ask him to apply or give him notice of the position?
Ні, я його не
No, I did not inform you about this position. This information was available for the public, and also that refers to my position as well. So the human resources, they would place these announcements on the website, and they also, do this. So I assume that maybe he also used this opportunity. What is your role in him winning the competition? No role at all. And moreover, I did not vote for him as the candidate. I, did not take any actions, and I informed the commission. But we have the document from which we see that you did vote for. This is incorrect. I voted for him for the second time when he was already in the position in NABU. So when he was employed to NABU, I informed the commission that I used to work with him before, so I did not vote. But when he already was employed to NABU, there was the situation when there was another job opening of the head of the department where he used to be the deputy head. Because the head of the department became the deputy head in another department. So since I informed about this before, moreover, he was already my subordinate, so I had no need to inform the commission twice about the relationship that we used to have. So the first time he was employed to NABU, I did not vote. I informed the commission, and all of this is in the minutes of the competition commission. Perhaps you are speaking about the second case when he already was advanced to the position of the head of the department.
We have gone over the hour that has been allotted, and I just want to finish up with one other question about a relationship. In 2021, you were party in 2 administrative cases as a complainant, which were considered by Judge Natalia Petrova Cherenichenko. Is that correct? Okay. And her daughter, Irina, works as the chief specialist of the International Legal Department within NABU and is your subordinate, correct?
мені невідомо такі обставини.
I don't know about this. I don't know.
У мене немає
I do not have the employee with this last name Cherednichenko.
Інше прізвище, але це донька судді Чередніченко.
перепрошую.
Is this the daughter of? She may have another last name. Yeah, I mean, your subordinate may have another last name, but is she the daughter of the judge Cherednichenko? I don't know.
Я не маю доступу.
Kuzmichova?
А, Кузьмічова, да, є.
Yeah, yeah.
Yes, yes,
Кузьмічова знаю, да, да, да.
yes.
Yours.
Да, вона моя.
Yes, she my subordinate, but the question is, frankly speaking, this fact, I learned about this fact for the very first time. I have no, access to the personal cases of all of my employees. And
First time. I'm sorry, you learned about what for the very first time?
Про те, що вона
about the fact that she is the daughter of Cherednichenko, the judge that you have just mentioned.
About that?
щойно.
Just now.
Was totally, you were unaware of that, had no idea.
Абсолютно не знав.
No.
So there would be no need for you to have asked for a recusal of the judge, just so the appearance of a conflict of interest was not present?
Ну, звичайно, я
Of course not. I was not aware.
So you're saying this is a revelation to you right now. You had never heard of it before.
Не чув.
Is the case
I didn't.
pending, or has it been resolved?
It was already resolved and checked by the courts of appeal and the Supreme Court. So in any case, if the decision was illegal, it would have been abolished by the courts of high instances. And I can explain the conditions to the case, and you will understand that my requirements were completely legal and well grounded. So
I don't need to know your legal theory here. That's not what I'm concerned about here. What I'm concerned about is the fact that what you're saying is this individual, Irina, who is your subordinate, her personnel file included her, the information of who her family was or is and the family ties. And I guess you're saying that during the competition to acquire her services, Irina's, you were involved in that, were you not? In her hiring? Were you involved in her hiring?
Я не мав абсолютно.
no, I didn't. I had nothing to do with her employment. I was not a participant to this process, therefore I was not aware.
There's no way that you would have been able to find out of the relationship.
Абсолютно.
No.
No further questions.
Можна питання?
Ігор,
May I ask a question? Tell me, please. I cannot imagine that you have no idea about the employees of your big department. Well, when you were appointed as the head of the department, when was it, of the legal department? It was November 2015. And when has this girl been employed? She has worked not for a long time in our department. I cannot tell you exactly. Maybe this was the period of from 2017 or 2018. But now she is on the maternity leave for over 5 years. I see. So frankly speaking, this information was new for me. I can explain the procedure of selection of the employees to NABU. No, we are aware of it. So I have no information about the parents, and I don't even have the need to clarify this information. Okay, Ihor Stepanovich, we have run out of the time limit for this interview, and finally I would like to ask you one more question. According to our information, for the period of work in the NABU, you were not held accountable for didn't have any disciplinary fines, but we have the materials that you did have disciplinary deed, but you were not fined or sanctioned because the term was already too old. And the situation was the following: that the woman who worked in the department, she was fired because the term was over. But that woman was pregnant then, and the law guarantees the employment for such employees. And if she cannot be employed in the NABU, then in such case there must be 3 months payment preserved. And you, as the head of the legal department, allowed her dismissal without such guarantees. So in fact, she was discriminated in this case. And further on, this was recognized as illegal, and NABU lost the income that was supposed to be paid to her. So how can you comment this? Why did this happen? Was it some personal attitude to this woman, or maybe you were not aware with the norms of the law on the guarantees to pregnant women? Why did this happen? Thank you for your question. Well, first of all, I would like to say that before the decision was made on her dismissal, I was not acquainted with her. I have never communicated with her. We did not have any relations or unpleasant relationships. So was it because you were unaware of the norms of the law? No. The law on the National Bureau has the special norm saying that the appointment for the position to the National Bureau only is done due to the competition. And the law on the civil service also said that the appointment without competition can only take place in the cases that are envisaged by the law on the civil service. And the moment when the decision was made on this employee, we had the single practice, and it was confirmed by the decisions of the courts on another employee, when we did not suggest when certain positions were cancelled. So the guarantee that you speak about, it's in the Code of Labor Law, and the law on the civil service says the following. If the law on the civil service decides the matter, Ihor Stepanovich, sorry, I'll be laconic. Do we understand you correctly? In your opinion, NABU has a special status, and for pregnant women, employees of NABU, such guarantees do not cover. Well, this order has not been approved by me. We have the distribution of powers, and the orders on labor questions is agreed by my subordinate employee. I'm not the one to approve this, but the NABU practice is the following, that the appointment to the NABU back then only could be done by the competition. And this is something that we always defended. And this was the first case when the court was on the side of the employee, when they have interpreted the norms in a different way. So no other practice of the Supreme Court, given the specifics of the NABU law, was before. So my employees, answering the complaints of this employee, I was only using the law, the rules of NABU. Of course, when we got the decision from the Supreme Court, we put it into practice, and we never violated her rights. When we got the decision, we have fulfilled it. I understand the specifics about the Code of Labor laws, but this was the general legislation, and we were using the special legislation that regulates our activity. I see. Are there any other questions for the candidate, Mr. Yarchak? Oksana? If I may, let's go back to the house that we talked about, the loan. In your written explanations, you specify that you tried to sell the house of your father. So somehow trying to tackle your financial issues. But at the same time, in the materials, in your materials that were collected by our employees, there is the receipt stating that you had the previous agreement about concluding the purchase and sale agreement on this house for $250,000. So for the moment of the agreement, so in fact, this house in 2008, you tried to sell this house in 2008 for a high amount of money. How can you explain these discrepancies of your written explanations that you provided today, and the receipt that is attached to the materials? In 2008, we were actively looking for the clients to purchase the house of my father. This house was already finished, and it was comfortable, and because when I bought it, when I purchased it, it was not appropriate for living. I would like to clarify, does this receipt refer to the house of your father? Yes. I have already explained this to Yaroslav Mikhailovich, that this was the receipt where it stated that this was my father's house. Because it indeed cost that much money then, and using this difference between the house, I was going to use that money to do the reconstruction of the house that I bought with the loan money. This was the idea of this transaction. You are a highly qualified lawyer, and you have a successful legal career and you make the misprint in the receipt of on the $250,000 and you confuse the address of the houses, please take a look that this was in 2008. Okay, 2008. And of course, at that moment, I had certain skills of the lawyer and I had experience in the prosecution office, and it was rather significant. But I'll be honest with you, my greatest experience that is helping me in my life, I didn't get it in the prosecution office. I got this experience in the private sector and in the National Anti-Corruption Bureau.
Yes, really, I had some experience, but that was a typo. That is a mechanical typo and nothing else. It was not conscious, there was no intention to hide anything. Okay, but in this receipt, your father is specified as the witness. So, like, also the third person, Stepan Mikhailovich, your father. Yes, I understand, but it is a typo. I'm saying I've provided you confirmation that in 1999, accordingly, I gifted the house to the father, and accordingly, this is information which does not influence my integrity in any way, in my opinion. If I made that mistake, probably that is more of a legal question rather than a question of integrity. Do we have any other questions from members of the AGE? If there are no other questions, Mr. Ihor, in such case, you now have the opportunity to address the AGE with your concluding remarks, and I would like to remind you, please be up to 5 minutes. First of all, feeling the duty before Ukraine and Ukrainians, for the sake of our country, I've decided to participate in this competition. In my opinion, my previous experience of working in different spheres absolutely allows me to feel that I will be able to hold the position of the judge of the Constitutional Court and to make a significant contribution in order to improve functioning of this body. In my opinion, together with previously selected candidates for this position, we will be able to at least conduct minimum reforms which will allow to speed up the process of work of this body, and accordingly we will be able to create all the conditions for the Constitutional Court to work efficiently and effectively, to work in such a way that those laws, those legislative acts and regulations which contradict the Constitution would not be effective for a long period of time and would not create prerequisites for the violation of the citizens' rights and of human rights set out by the Constitution of Ukraine. I sincerely believe, and I'm absolutely convinced, that members of the expert group will take a correct and reasonable decision, and I hope that maybe those shortcomings that you maybe have seen in me will not create prerequisites for you to see some lack of integrity in me. As an or any other human being, I can make mistakes, but please trust me, I try to live according to the law and God's word. So thank you for this opportunity. Thank you for listening to me. Glory to Ukraine, and I count on your correct decision. Glory to heroes. So we are grateful to you for participation in the competition for the position of the judge of the Constitutional Court. Thank you for answering questions. Thank you for communication with the AG. Thank you for providing information. Thank you for answering questions today. All of this will allow us to objectively assess your compliance with those high moral standards that are required for filling in the position of the judge of the Constitutional Court. And now, interview of the AGE with candidate for the position of the judge of the Constitutional Court of Ukraine, Yarchak Ihor Stepanovich, is over. Ihor, please leave the premises and we need to discuss.